So welcome back to the show, everyone. My next guest, I'm so excited about bringing him on. I have with me Howard Snader, and Howard is a board-certified expert in criminal law. You wrote this book, and before you came on the show today, you said to me, Carol, I wrote a book for everybody to have all of the answers that they need in order to, if something happens to them. Welcome to the show. Tell everybody a little bit about yourself and why you wrote this book.
Carol, it's great to be on. I really appreciate the opportunity here to reach out to a whole bunch of people outside of my normal clientele that come in the door.
Sure.
Every day I'm asked, certain questions. What's going to happen to me in the case? How do I talk to a judge? What does this court proceeding mean? And I used to do it in a letter to clients and try and explain some things, and it just wasn't enough information. So I wrote a client's guide to Arizona's criminal law and procedure, and that way, hopefully, by getting the book, people will actually have an understandable way of understanding the court process, the different steps, and how the case navigates through the system.
I love the book. Now, this is not just one. This is number 2, if I remember correctly. Is that correct?
This is book number 2. My first book, Busted, was basically about the myths or the misconceptions you had about criminal law. This one I really wanted to hit home and educate people on all the little things that happen in a criminal case.
And that's what I want to ask you. So let's talk about what a criminal case really is.
It's a fair question, and a lot of times I get questions saying, hey, I want to sue somebody. That's not what I do. When you sue somebody, that's what we call a civil case, and you're trying to get some money for having been injured. Criminal case is when you have the weight of the government accusing you of a crime. And it sounds silly when you think about a criminal speeding violation or the domestic violence or the sex crime cases that I get routinely. Criminal cases means the government's trying to put you in prison. They're trying to give you a sanction that's going to affect all of your professional licenses, possibly your driver's license, your immigration status. Those are the things that I deal with on a day-to-day basis.
And, everybody has a different story, too. And there's all sorts of different types of criminal cases out there, right? And in this book, just before we go on, I want to ask, the person who, let's say, when should they get this book? Should they get it because they know their son might or daughter might be someone that might, when should they start reading the book?
Ideally, hopefully they never have to read the book.
Right.
But if you want to understand how the criminal process works, you need to get it either expecting trouble or you've already been contacted by police. You need to have that book in hand so you can understand how an arrest happens, how your initial appearance happens, how your arraignment happens, how all the status conferences happen, a plea bargain, trial, sentencing. It's all covered in the book.
And I love the way that you made it so understandable for anybody to read. I want to talk about the difference between a misdemeanor and a felony.
And they both have substantial consequences. Even though a misdemeanor is, in Arizona, a worst-case scenario, 6 months in jail and a $2,500 fine, it can still affect everything from your driver's license, fingerprint card. That could have mandatory jail, counseling. There are all sorts of things misdemeanors have. Fortunately, it's a misdemeanor. When we start talking about felonies, a felony by definition is any crime where you could actually receive a punishment greater than 1 year in prison. And prison is where they lock you up. There's no work release, there's no work furlough. You just go away. And then, of course, you have all the collateral consequences of having a felony permanently on your record. Right.
I would die. I would die if something like that happens, and it can happen to anyone. We've talked a lot about that, even on my radio show before, that it can happen to anybody at any time, especially with, let's say, some of the no-tolerance laws that they have here in Arizona.
That's true for DUIs. The Cardinals coach was arrested just a couple months back. He's going to go through the process, and I would like to think he's never done it before. Had an email just the other day about a 18-year-old kid who they waited 2 years to charge. He was convicted, now he's dealing with all the consequences at age 25, and there's nothing I can do 5 years after the fact.
That's a shame.
As soon as you're contacted by law enforcement, you got to get an experienced attorney, a board-certified expert like myself, who can really walk you and guide you through the process.
You've grown so much, too. How long have you been doing this again?
I started my 30th year.
I want to get that out there because it has been a while. You really are truly experienced. So what does it mean when a court sets release conditions? What does that mean?
The judge gets to decide what your conditions are pending your next court appearance. So a judge will set your release conditions at either your initial appearance, which means you've normally been arrested, or at your arraignment, which is when you get a letter in the mail, what we call a summons, saying come to court on a certain day. Your release conditions in most cases are your own recognizance, what people call OR. And that's just your promise to appear. But that can still come with conditions of an ankle monitor. It can still come with curfew. On domestic violence cases, it can require you to not live at the house, not have contact with the victim. Those are real problems. So again, getting me on board at the time of the initial appearance or the arraignment, we can oftentimes deal with those release conditions. Of course, we want to stay away from the bonds. A lot of clients don't have substantial money to put forward to get out of jail.
When people call you, do you do a consultation with them? How does it work?
We do a consultation. It's a free consultation with anybody that calls our office asking for help. I would like to say everybody coming in will hire us. That's not the case. My goal has always been to help people. And we will talk to people every day. We know they can't hire us, but we do try our best to answer their questions and set them on the right path.
Thus, the book as well.
The book, if they come into the office, they'll get a copy of the book, but more importantly, I have about 50 copies right now that are readily available, and if they were to call the number they see below, we'll be more than happy to ship it out to them.
Absolutely. I think that everybody really should have this book, just because anything can happen really to anyone at any time. So what is a status conference? What is that?
I get emails all day long. I have an initial pretrial conference. I have a status conference. We have an omnibus hearing. It doesn't matter what the name of that process is. It's a conference between the day you're advised of the charges and pleading not guilty, that's your arraignment, and the resolution of the case, which is a plea bargain or a trial. So all the little conferences that take place, normally about 30 to 45 days apart. Different courts call them different things, but it's basically where the attorneys come in, tell the judge, hey, this is what's going on in the case. Do we need to get witnesses on board? Do we need to get the court involved in trying to get some motions or police reports or other discovery available? It's just a stopgap where the parties can ask the judge for help if they need it.
And that's a good thing that they offer that, I think.
It is.
Because sometimes people are not necessarily, didn't do something wrong. That's where you come in, or you can help them at least lower their time. Is that correct?
Oh, absolutely. The majority of cases, we're different from a lot of law firms. A lot of law firms are churn and burn or mills in some way, shape, or form, where they come in, clients come in, and they expect the person to enter a plea bargain, never go to trial. We don't have that mindset. We assume every case coming in is going to trial. We dot all our I's, cross all our T's. And do they go to trial? Not normally, but by doing the extra work in preparation for trial, we're often able to get better results.
So everybody that gets, let's say, in trouble in some way, it doesn't always go to trial.
I'd say 1%, 2% of all cases go to trial. Normally they can be resolved through a plea negotiation. Oftentimes that means pleading to a lesser charge or a lesser penalty than what you might face heading into a trial. That's certainly the case for felonies. Misdemeanors, sometimes going to trial is actually a better option.
So when somebody is in court, okay, should they say something to the judge, or how does that usually work? Or is it usually you that does that?
Clients all the time say, when can I tell my story? And a lot of times you don't have that opportunity. The opportunity to tell your story is normally when you're being sentenced or if you're at a trial, when you're on the witness stand subject to being cross-examined. We do work with our clients on what to say to the judge. So when the judge does ask those questions, they have a real good, crisp, clear, concise response. But when you tell your story, it's usually in mitigation of a sentencing, or it's going to be a trial after being prepared so that you can hopefully convince a jury that you didn't commit a crime.
Now, I know we're going through a lot of these things. I want to come back to the book again. All of these things that we've been talking about today, are they in the book?
Everything that we're talking about today is in the book. Our conversation today can't even come close to the information contained in there.
Right.
You can either go out and get the statutes and read the criminal law and procedure books, or you can get my book, condensed down, readable, understandable, tells you how things work for both misdemeanors and felonies, and of course, the book doesn't cost anything.
It's perfect. Okay, so what's an appeal?
An appeal means that you've lost. And clients have a major misconception, hey, I don't need to hire a lawyer, I'll just go to trial. And it feels like a sitcom response where they go to trial thinking they can do it themselves, or maybe they can do it with a private attorney that doesn't have my experience, a public defender. But an appeal means you lost. That's the bottom line. And coming back in after the fact to challenge a case, great. Let's say you win the appeal. The misconception of an appeal is that if you win it, your case is dismissed. Again, that's wrong. Normally, when you win the appeal, all you get is the case sent back to the lower court, the trial court, and it picks up from where the error was made. It's usually at sentencing or at trial, in which case you get a new trial.
But they use you still, no matter what?
Oh, absolutely. From even before they're charged with a crime, all the way through the appeal.
So we have a few more minutes, and I want to also talk something about a couple different things. You are so passionate about what you do and helping people. I know this so much because, you know, you've been on my show, my radio show, so many times, and we've talked. Something that I do say on the radio that I'd like to say here too, you know, anybody can get in trouble at any time. Maybe you're out there and maybe someone, you know someone who has gotten in trouble. It's great. He does a free consultation. This book is awesome for everybody to have, just to understand, you know, what the procedures are, what's going to happen to you. I always say, put your phone number in your phone, right? I say that on my show all the time because you never know when something like this, you know, you need something like this.
It's the business card you need to have and never want to need.
Right.
What's even worse, I try and tell clients, you're not going to remember my name. So great, you've put my phone number in your phone. When you're stressed out because you're at the side of the road getting pulled over, cops are banging on your door with a search warrant, you're seeing your loved one handcuffed and taken away, you're not going to remember my name. So put my phone number in just as criminal attorney, and that way it's there, and you have me on speed dial.
Right. And, you know, what's really awesome, too, is that I love that you are so wanting to educate people out there and really help them understand the law.
I love the law. 30 years ago, I wasn't sure what I wanted to do except become a lawyer. In 30 years, I've been a pro tem judge, I've been a prosecutor, I've been on every end of every misdemeanor, every felony. I've testified for the state, I've testified for the defense, I've testified for the state bar at different proceedings. So I know the ins and outs on the law, the ins and outs on the ethical obligations of an attorney. I'd like to think that if you're in trouble, I've got to be your first person that you're going to be given a call to help. Absolutely.
I agree with you 100%. You know, I too want to get out there again what it means to be a board certified expert in criminal, that it's not just DUIs, you know, just family law. There's so much.
Board certification is a certification issued by the state bar. I received mine in 1995, and I have to renew it every 5 years. So you've got to stay up to speed on this area of the law. In 95 through today, there are only 100 attorneys that are certified in Arizona as board certified experts in criminal law. Half of them work for the government. So there are only a handful of us in private practice. So when you're in trouble, I hope you seek out a board certified expert. Hope you seek out me.
Absolutely. What would you want to leave them with? We have a couple of minutes.
The one thing I want to leave them with is that criminal law is scary. You're at a position where the government can take away your liberty, they can take away your reputation, they can take away your family, they can take away so much. And it doesn't matter whether it's a truthful allegation of a crime or not. When the government steps in, you have all the power of the government going against you. So when you're in contact with law enforcement, if you think it's coming down the line, you need to reach out and contact a criminal attorney right away. The case can be beat, won, dismissed if you get knowing counsel guiding you from the get-go. We have cases all the time where just because we can get involved with the detective, get involved with the prosecutors, it won't be charged.
And especially if you do something right away. It's a great book also for everybody to have, just in case. You'll understand the law from start to finish. You absolutely will. You know, I really appreciate you being here, Howard, because, again, I think what you do, unfortunately, people need it. They do.
Absolutely.
And you said it best when you said, how did you say it? It's the card
that you need to have but never want to need.
Absolutely.
Especially for the parents whose kids are always getting in trouble.
Right. And you know what? It happens. It doesn't make them bad people in any way, shape, or form. Like we've said it so many times, bad things happen to good people. But this book is just a phenomenal book. Again, I believe that everybody should have it to learn the law, and that's what he wants. He does free consultations with everyone. I really appreciate you being on the show and sharing your book and helping everybody out there understand, you know, what this law is all about. You know, I really appreciate too the audience that is listening, listening too, because this is for them as well. So we're going to be right back